Good afternoon, everyone. It's a pleasure to have you for this final panel discussion of the day. So I'm a policy advisor at ICoCA. And as you may know, ICoCA is turning 10 years old next year. But even though we are younger, I would like to wish a happy anniversary to the Geneva Academy, which is turning 15 years this year. And we are co-hosting this panel with the Geneva Academy, so it's really my pleasure to introduce you to the director, Gloria. And we prepared this panel together. The Geneva Academy has been contributing a lot over the last 15 years to research and to the training of a new generation of IHL experts. They also produced a commentary of the International Code of Conduct, so I really invite you to look at this resource. And of course, the idea of this discussion comes from our frequent contacts, so we are very happy to co-host this with the Geneva Academy. Perhaps a word also on the ICoCA for those who join us this afternoon. The International Code of Conduct Association is there to operationalize human rights and international humanitarian law rules to private security providers. We do that through monitoring, through certifying new members, through capacity building, through training. And we want to advocate for responsible security. And actually, it does work. We have 120 members who strive to respect human rights and are committed to respect the code. And they provide security services, guarding premises, airports, extractive industry, all over the world. So they do a great work, and we are there basically to extend this family and bring more private security actors in this code and in this dynamic of respect. But when we speak about private security, very often we think of some other actors. And in recent years, we've seen a real expansion of military providers, contractors, providing escorts, logistics, training for the military. We've seen them in conflicts all around the world, in Afghanistan, in Iraq, with a number of contractors which was far exceeding the number of soldiers actually deployed. So we have a galaxy of other actors providing military services. But then when I say to people I work with the International Code of Conduct Association, there's yet another group of actors which come to the mind of my contacts. They say, are you working with mercenaries? And I think in recent years we've seen also coming back those soldiers of fortune, various groups. It's not a new phenomenon. I remember when I started working in the humanitarian sector, we were talking about executive outcome, Sandline, operating in West Africa. And we have seen them morphing. It's an industry which is evolving constantly. And, of course, they give a bad name. They have sometimes a terrible record in terms of abuses, violations of human rights or international humanitarian law. So there are lots of confusion. There's lots of questions regarding those different actors and regarding how they could be sometimes brought to justice, how to engage with them, what are the consequences of their actions. There's lots of also secrecy around their actions. Sometimes they are used precisely to cover activities by the states, to diffuse responsibilities. So there are many current questions about private military companies, private security actors, and the confusion around the different categories. Also, in terms of law, fortunately, we have many instruments, but those instruments sometimes have different definitions, and we need clarification, and we need also to discuss concretely how the law can be applied when private actors operate in conflict and violent situations. For this, we have a great panel today. So we have prepared for you the bios. So please have a look. I will introduce them briefly only so you can read about their expertise. We have, I mentioned Dr. Gloria Gaggioli, who is a law professor and the director of the Geneva Academy of IHL and Human Rights. We have Sorcha MacLeod, and I'm so sorry because I've never been able to pronounce your name the right way. So she's also a professor, and she's an expert in human rights and a member of the United Nations Working Group on the Use of Mercenaries. She's been working on this issue for some time, so has lots of experience on this issue. We have also Ori Swed, who is assistant professor at the Department of Sociology, Anthropology, and Social Work at Texas Tech University, and also devoting his time and the time of his students to work as part of a lab on these issues. And finally, we have Alessandro Arduino, who is the Principal Research Fellow at the Middle East Institute at the National University of Singapore. So thanks to all of you for joining us. And without any more delay, I'd like to give the floor to Gloria for an introduction on the subject from the legal perspective.
Thank you very much, Vincent, and good afternoon, everyone. It's a pleasure to be here with you today. So I was asked to set the scene and to look at the international legal frameworks pertaining to this issue. So for setting the scene, I think that Vincent already did a great job about talking about the growing importance of PMCs in the current environment. What I would want to highlight is that the vast majority of PMCs provide actually legitimate services that are benign or quite beneficial from even a human rights law perspective or even IHL perspective. So, for instance, they might intervene by safeguarding shops, homes, public spaces from looting or vandalism. However, there is another trend which is more concerning, an evolution where we have PMCs that are being contracted for actually conflict aggravating and or illegal ends. So states are sometimes contracting PMCs to serve as proxy agents inside or outside the domestic context. In this framework, you might think about the Wagner Group. You've seen the operations of this group in Ukraine, but also in Central African Republic, in Libya, in Mali, and many accusations have been made of this group committing extrajudicial killings, acts of torture, and forced disappearances, looting, and so forth and so on. There might be various rationale in play for states or other actors to recourse to such bodies, such entities, because obviously this is a way to evade obligations under international law by thinking, okay, let's use these type of entities so that the responsibilities of states cannot be recognized, or the responsibilities of organized armed groups, because they also contract this type of military actors. So this is the problem we have of an increased amount of human rights and IHL violations perpetrated by these private military actors. So now, in terms of terminology, Vincent mentioned the difference also between different type of groups, PMCs and PSCs. You can find different typologies in the literature. But at the end of the day, I have to tell you that from an international humanitarian law perspective, so the body of law that applies mainly in armed conflict situations, you do not have even the mention of the notion of private military and security companies, and even less a typology of companies. So you do have, however, the term of mercenaries that you find in additional Protocol 1 to the Geneva Conventions. However, and don't worry, I'm not going in the details that can be painstaking, but in Article 47 of Additional Protocol 1, you have a definition of mercenaries that is so restrictive that actually it would be very seldom that you would be able to say that members of PMCs correspond to mercenaries. So actually, if you take the international humanitarian law perspective, you have to look at each instance in order to determine the status of those entities, those groups, which might be belligerent parties or not. You might have situations where there are members of those groups are combatants. In other instances, they are civilians. And the label, the designation, would not matter from an international humanitarian law perspective. So for policy or political reasons, that might be relevant, but from an IHL perspective, it's not really the focus. Let's have a look now at the international law obligations that pertain to such PMSCs and such companies. I will focus really on international law, not domestic law. So from an international law perspective, I shall start with international humanitarian law, right? Because this is the international legal framework that regulates armed conflicts, and this is the title of our panel. So first thing I would like to highlight is that IHL would apply to anyone in the context of an armed conflict situation, be it an international armed conflict or a non-international armed conflict. So it applies to belligerent parties, but also to private individuals and potentially to companies, especially if they are belligerent parties. So even a security company which is deployed in an armed conflict setting and saying, well, this is not our objective to take part in hostilities. Okay, this might not be your objective, but you still have to abide by international humanitarian law rules. And so members of PMFCs might even have their individual criminal responsibility involved if they participate in war crimes. So a first really important point is that irrespective of the label, all the companies and individuals working for those companies and being deployed in armed conflict have to abide by international humanitarian law. Now, IHL specialists are very much interested in knowing, okay, who are combatants and civilians, because obviously the protections will depend on this qualification. So this is a big question to know what is the status of members of PMSCs. Because, of course, who would be targetable would depend on this qualification. So if members of PMSCs can be qualified as combatants, then they can be the object of legitimate attacks. And if they are civilians, no, they are protected from attacks. Moreover, if they are combatants, then they cannot be prosecuted for all the acts of hostilities they perform in accordance with humanitarian law. So there is a huge difference depending on whether you are faced with combatants or not. And so, as I said, this would depend very much on the circumstances. So, for instance, if members of PMSCs are being integrated into the regular armed forces, then they have to be considered as combatants. If they are under the responsible command of a belligerent party, then they have to be considered as combatants. If not, these individuals are civilians, and so they are protected from attack unless they directly participate in hostilities. And that's another big and gray area issue. So when can we consider that personnel of PMSCs directly participate in hostilities? And actually, it's not only when they take part in combat operations. I mean, even guarding weapons or guarding a military barrack would amount to a direct participation in hostilities. So often, I have the impression that members of PMSCs do not necessarily realize that their activities, although they do not take part in hostilities, do not take part in combat operations, is already direct participation in hostilities, and therefore they might lose protection. So this is, I mean, from an IHL perspective, just to highlight that we need to integrate a lot of nuance in the analysis. We cannot say, well, they are combatants or they are civilians. This will very much depend on the circumstances. Let me go to another legal framework that is relevant. It is international human rights law. So you are certainly going to speak about this. So traditionally, the international human rights law perspective is to consider that only states are bound directly by international human rights law treaties. However, unfortunately enough, things are progressing, and therefore increasingly we do consider that private actors, and especially PMSCs, have human rights responsibilities. This has been recognized also by the PMSCs themselves. So if you look at the International Code of Conduct that you mentioned, and the reason why we are here, actually, you have really, through the code, a recognition of the members and affiliates that they have human rights responsibilities, which was a huge step forward. I mean, having a document like this, which is not a treaty for sure, but still you have an international instrument document like this where the companies themselves recognize, yes, we do have human rights responsibilities. So this is actually huge and can contribute really to the evolution of international law. Then I shall mention as a footnote for that, that if the members of the PMSCs are actually integrated in the state armed forces, then they have more than just responsibilities. They have obligations under human rights law, which are exactly the same as the obligations of the states. So states cannot use proxies, mercenaries, or PMCs, whatever you want to call them, in order to evade their own human rights obligations. Regarding the legal frameworks, I would like to mention also briefly international criminal law. That is obviously relevant because members of PMCs, if they commit war crimes, they can be prosecuted for that at the domestic level, but also potentially at the international level, even by the ICC, International Criminal Court. So now, let me look at whether we have something else, because now I'm talking about IHL, human rights, international criminal law, and you might think, okay, but there must be something special about the PMCs. We must have a special instrument on that. And actually, well, we don't have a convention that deals with the obligations as such of PMCs. What we have is the Montreux document from 2008, but it relates, it's a soft law document, so it's non-binding, but it relates to states' obligations in relation to the PMCs. And so there you have several obligations flowing from IHL, human rights law, and they concern the states contracting the PMCs, the territorial states, and also the home states. So this is a very useful non-binding document because it shows also the breadth of the due diligence, positive obligations of various states in order to make sure that the PMCs respect IHL and human rights law. Then, of course, we have the International Code of Conduct, which this one is really focused on the obligations of private security providers themselves. So this was really an extremely important step forward. As you mentioned, Vincent, many major PMCs have signed the International Code of Conduct. We have this recognition of human rights responsibilities in there. But, of course, the system is not perfect. I mean, no system is perfect. So. And so there is always room for improvement. So, for instance, one area where we could have some improvements is to make sure that small private security providers would also become members and sign the International Code of Conduct, which is mostly signed by the major ones, the big ones. But the small ones, maybe for financial, economic reasons, they do not decide to become members. Another point is that obviously the International Code of Conduct is already quite comprehensive, but we could have some updates. So I think that in certain areas, updates would be quite relevant. So one area that comes to my mind is in relation to new technologies. So should we try to think about the situation where PMCs might have access to cyber technology, autonomous weapons, using artificial intelligence for perpetrating, conducting hostilities? So how would we tackle this issue? So this is one of the areas where we could envisage some innovations. So despite all these evolutions, we do have an accountability deficit. And there are several reasons for the accountability deficit, and these are not only legal reasons. There are also some contextual and factual reasons for that. So first, you have a contextual impediment to accountability, so to making sure that when members of PMCs commit crimes, they are being prosecuted. And often, so the principle is there, but often there is impunity, so it does not happen. Why? Because already in conflict zones, you have a reduced law enforcement capacity, so maybe the territorial state is not really in a position because of the conflict to prosecute those individuals. It's often difficult to collect evidence, to conduct investigations. There may be a lack of willingness by the contracting state also to collaborate in the prosecutions. So sometimes there is an orchestrated impunity. So I mentioned the Wagner Group. I think this is quite obvious that apparently there is no interest in prosecuting the crimes committed by this group, although some states have now issued sanctions against the Wagner Group. Then there is also a more legal dimension, which is the corporate dimension, meaning that from an international law perspective, you do not have a system of responsibility attached to corporations as such. So you have state responsibility or individual criminal responsibility, but no responsibility for corporations as such. So you do have several reasons why there is this accountability gap. I'm going now to conclude with a few ideas about the way forward. For the way forward, I think we can continue indeed to strengthen the legal and regulatory framework, also to make sure that the code of conduct, for instance, remains relevant by involving, by integrating also new challenges. But we have to work very much also on the implementation of existing norms and existing rules. So dissemination is key. Training is essential. So since I'm leading an academic institution, I would like to highlight that training is not only about, stating the law. Often when we are dealing with members of PMCs, we have to make sure that they integrate the law. So it's more than just opening books. I mean, it's also having, role plays, situations that are lived by the persons being trained, lessons learned processes, etc. So training, using also, we could, using new technologies to favor immersions before the members of PMCs are being deployed. We should also have a focus on the procurement of weapons, making sure that PMCs do not use weapons that are actually unlawful. Focus on engagement with various PMCs, and not only the nice ones, if I might say. I mean, organizations like ICoCA, like Geneva Call, like the ICSC can really engage also the ones who are known for violating the law, and I think this is where we should focus on in the years to come. We have also to work on raising awareness about these gray areas. And we could also, from an academic perspective, look into some innovative researches. So for instance, we could try to look into what are the factors beyond law that can contribute to the respect by PMCs. So for instance, economical factor or the reputational factor. So what are the other reasons why members of PMCs would actually abide by the law? I will stop there, and I thank you very much for your attention.
So thank you so much, Gloria. You managed to cover the whole spectrum from international humanitarian law to criminal law to human rights, and also because you know us well, and I think the Academy was there at the beginning when, during the time of the drafting of the code as well. I think the suggestions you make are very relevant in terms of looking at the codes as an evergreen document, adapting it to changing realities. But also, that was very cruel because all the suggestions you make in terms of training, in terms of creative ideas, I really want to start them all. So you give us lots of interesting suggestions and lots of work, actually. So thanks for that. Now I'd like to turn to Sotia. Yes, with my pronunciation, with my French pronunciation. Thank you. I forgot to mention that you are also a member of the advisory group of ICoCA, as well as Alex. Thanks for the work you do to support us. And the working group has been working, of course, on all these issues that you just mentioned, but you've been digging into some specific issues over the years, producing thematic reports which have been extremely useful on these activities, on the changing face of the sector. So thanks for joining us. Thank you.
I'm not sure. Oh, it is working. Thank you, Vincent. And it's wonderful to be back at the ICoCA AGA in person. It's lovely to see so many of you that I've known and met over the years. So yeah, let me just tell you a little bit about the working group, because I think that's always helpful to understand.
Sorry, we need to speak slower.
Yes, I forgot we've got interpreters. Yes. Forgive me, my apologies. So let me tell you a little bit about the UN Working Group on the use of mercenaries, who we are and what we do. I know that the M word, or one of the M words, mercenaries, often gets people's hackles up, as we say. But our mandate comes directly from the UN Human Rights Council under what's known as the special procedures. And we're a group of 5 independent human rights experts. We don't work for the UN. We're not paid the UN. We do this on top of our existing jobs. So I'm an academic, as Vincent said. And we have our mandate is given to us directly by the Human Rights Council, and it's renewed on a regular basis, most recently in September of this year. And we have a mandate to look at, yes, mercenaries, but also mercenary-related actors and private military and security companies. So that is the language that we use, because that is the mandate that is directly given to us. But we do understand that that is a controversial mandate. Our mandate is also a contested mandate. It is not one that is supported across the board by states. And the definitional issues are one of the main reasons why many states choose not to support the mandate. So it's a highly politicized mandate, and so we have certain states that would say all PMSCs are mercenaries, for example, that they regard them all as being one and the same. Now, on the working group, obviously it's a human rights mandate, so we're very much focused on human rights violations, but also violations of international humanitarian law. That forms part of our mandate as well. And we have our own definition of private military and security company that we have developed. Actually, our predecessors developed that definition, and we work to the international legal definition of mercenary. Now, as we've already heard, that definition is contained in the Geneva Convention, Additional Protocol 1, Article 47. It's a cumulative definition, and it is, as we already heard, very difficult to satisfy. So you have to have been recruited at home or abroad, specifically to participate in hostilities, that you did in fact directly participate in the hostilities, that you're motivated by private gain, and that the private gain that you receive for your labours is substantially more than a member of the regular armed forces would receive. And then there are some excluding elements. So if you're a national of a party to an armed conflict, you would not be defined as a mercenary. And of course that has particular implications. We've seen this in relation to Ukraine, for example. And if you have been sent on official business or for some official purpose, such as peacekeeping or training, then you would also not be defined as a mercenary. Now, all that the Geneva Convention does is define mercenary for the purpose of determining whether you're a combatant or not. And if you're a combatant, you get prisoner of war status. If you're not a combatant, you do not get prisoner of war status. So the Geneva Convention does not criminalize being a mercenary. But we do have substantial other international instruments that define mercenary in a very similar way, but also criminalize mercenaries. So we have an international convention, which only has 37 state parties to it currently, which takes a very similar, almost identical definition of mercenary. But the state parties to that convention are required to, at the national level, to implement domestic laws criminalising the recruitment, the training, the financing of mercenaries, and the deployment, actually, of mercenaries. We also have the African Convention on mercenaries, which again criminalises the recruitment, the training, the deployment, and the financing of mercenaries. And then, of course, we have national law. And many countries do, in fact, have domestic legal provisions that criminalise mercenarism. And they do so in a way that is much less complicated in some circumstances than the international definitions. So, for example, in some countries, the simple act of fighting for another country, for a country that you do not have nationality of, can render you responsible under mercenary legislation, and you can be prosecuted. And we've seen this happening. So we've seen the removal of the requirement to be motivated by private financial gain. We see the removal of the requirement to to have been recruited specially to fight in the hostilities. All of those things are removed. And so we've seen domestic legislation being applied to all sorts of different actors. So we've seen it being applied to foreign fighters returning from various parts of the world and who've been involved in armed conflicts. Now, the working group is cognizant of the fact that we simply don't have a situation of we don't have a binary situation here. So we have mercenaries, and the reality is that some other actors, whether we call them private military companies, whether we call them private military and security companies, whether we call them private security companies, doesn't matter. In some circumstances, they may meet the definition of a mercenary. If they are directly participating in the hostilities and they meet all of these other criteria. But of course, as we said, at the other end of the scale, we do have private security providers or private security companies that are not participating in armed conflicts. They're not providing combatant services. But nevertheless, they would fall within what we in the working group, our definition of private military and security companies. And that is a corporate entity that provides security and or military services. And we have a definition of security, so that could be static guarding, it could be close protection. If we're talking about military services, it might be training. That might fall within the definition of military services. Now, if an actor is providing those services, then and they're not fighting in the armed conflict, they're not directly participating in the hostilities, then they wouldn't meet the definition of mercenary. But from our perspective as a human rights mandate, they might still be involved in the violation of international human rights law, in the provision of security services. So the working group has done quite a lot of work on the provision of security services which have violated human rights in the context of border management and migration, for example. The other thing that we have to bear in mind is that there is a grey zone in the middle. And the reality is that there are some actors which on any given day will not meet the definition of mercenary, that they provide legitimate private security services. So, for example, we've done some work on companies that have provided security for conservation projects. Perfectly legitimate security services. Nobody has any problem with them providing those security services for the protection of wildlife. But the problem is that they have, in doing so, in carrying out the provision of these services, they have been using firearms against local civilian populations. They've been arbitrarily killing people without any due process. So for us as a human rights mandate, that's really important, and it's important that we look at it. That same company, on another day, under another contract, will provide military services, will provide combatant services, and would appear to meet the international legal definition of a mercenary. So it's a slight, we have this, as I say, we have this fluidity, this sliding scale. And from the human rights perspective, as long as you're not violating human rights, then we're not going to be looking at you. But because of the mandate that's been given to us by the Human Rights Council, we do have to look at this spectrum of actors. And I want to finish on two notes. One of the things Vincent said at the beginning, mercenaries are not a new story. But what is new and what is different about contemporary mercenaries or actors that appear to meet the definition of mercenary is that they are proxy actors, as we've already heard. And the working group we've issued several allegation letters in relation to states recruiting mercenaries from a variety of different countries, very often already conflict-affected countries, and transferring those recruits to different armed conflicts. So we've seen Turkey has done this in relation to the conflict in Nagorno-Karabakh and also in relation to Libya. Russia has done it in relation to Libya, in relation to Central African Republic and elsewhere. So it's there's a big problem here with these proxy recruitment and deployment practices. The other thing that I think it's important to note is that contemporary mercenaries are different from the old school idea of mercenaries, in that we're seeing significantly larger numbers than we did historically. So in the past, the number of mercenaries that might have been deployed might have been a few dozen. Maybe up to a few hundred. What we're seeing today are mercenaries being deployed in the thousands. In different contexts. Now, some contexts it's only a few. In other contexts, it's into four figures. So we've got that is a significant difference, and that has huge implications when it comes to accountability and holding these actors accountable for human rights violations and the commission of war crimes. Because they are being recruited and deployed as proxy actors on behalf of third-party states, not parties to a conflict, they are also being equipped with significantly heavier weaponry. And of course, that has a disproportionately high impact and negative impact on civilian populations. So what we're seeing is that the conflict is continuing. We're seeing peace processes being undermined. We're seeing destabilization by these actors. And most significantly, we're seeing civilian populations experiencing grave human rights abuses, and in some cases, they rise to the level of war crimes. So that's extremely concerning. The second point I want to make, and to follow on from what you were talking about in terms of the regulatory framework, there is another framework that is extremely important, and that is the open-ended intergovernmental working groups process on the regulation of private military and security companies. And even there, we see this political difficulties and political tension playing out, because the first iteration of that working group, I think it's more than a decade old now. I feel so old these days when we start saying it's 10 years of this and 15 years of that. With the open-ended intergovernmental working group, the first iteration was mandated to draft a binding instrument on the regulation of private military and security companies. What we have today, the second iteration, the second version of this open-ended intergovernmental working group, has this very complicated mandate to develop an instrument, not prejudging the nature thereof. That's the language that's used. So we now have a draft, we're now on the second draft of an instrument, which I call it Schrodinger's Instrument. It is both a draft for a binding instrument and a non-binding instrument at the same time. Yeah? Which makes trying to draft it and trying to determine what it should contain very, very difficult. But we're seeing the same discussions that we were having 10 years ago, 15 years ago, about the definition of private military and security company. And we talked about the Wagner Group briefly. The Wagner Group does not have a corporate body. It is not registered under Russian law. It doesn't. It may use corporations within its organizational structure. But if we have to think, if we really want to have an instrument that properly regulates these actors that are violating human rights, we need to be asking, well, would the actors that we have problems with at the moment, that we know are violating human rights, no matter who's recruiting them, no matter where they're being deployed, would they be covered either by international law on mercenaries, perhaps, because if you look, Russia has said to us in relation to allegation letters, we have not deployed mercenaries to Central African Republic. We have deployed trainers, instructors. They are not directly participating in the hostilities. So we're seeing this plausible deniability in in the deployment of these actors, and states denying that they are in fact mercenaries. So there's a real question there about when we're thinking about developing new regulatory initiatives, the actors that we are dealing with right now probably would not fit in the definition of a private military and security company that we currently are working on. And the difficulty that we have is, the Montreux document and even the code has been playing regulatory catch-up. It was trying, they've been trying to regulate what happened back in Iraq and Afghanistan and even Bosnia and elsewhere back in the 90s. And we've seen that the code has moved and shifted and changed most recently a year ago. But we have to be serious about the fact that as we currently stand, there is a huge regulatory and accountability gap when it comes to these kinds of actors. I'll stop there. Thank you.
Thank you very much. Thank you. So after this focus on mercenaries and the law of mercenaries, I think the last points you made are a perfect transition for the second half of this panel. We'll move a bit away from the legal considerations and go into the let's say the current state of play with private military actors in international relations. And to start this second half of the discussion, we have Ori, who's been studying them from a sociological perspective. So that's quite a unique perspective. So Ori, the floor is yours.
Thank you. Thank you for having me here. And it's been really interesting to be in the last couple of days talking to you all and learning from you. Now, the messages delivered here, touching upon many of the points that I'm going to address and many of the conversations that we all have. But before that, I would like to provide some background on the stuff that I do, so you would know how to interpret it and to know what does it mean. So I'm the director of the Peace, War, and Social Conflict Lab in Texas Tech. And in that lab, what we do is that we look at emerging security trend. That the nature of security is always secretive. We don't have enough information about it. And as such, we assume a lot of things. We fall into anecdotes. We fall into some high-profile case studies. And what we do is that we find innovative ways to collect data and to bring empirical clarity into discussions, and to figure out, okay, so this is a discussion, let's inform it with some empirics. So some example, we collected data on terrorist organization using drone technology, on information operation, looking at trolls and how do they operate, and variety of other projects. And one of those projects is looking at private military and security companies, looking at that sector. And one of the main takeaways before we'll get into the things here that I'm going to discuss is that, especially building on what's been said, is that for the practitioners, the definition, if you see yourself as a private security company, private military security company, or whatever, it's a public relation thing. It's not the main issue. The main issue is the legal issue. You need to figure out that if you perform a specific type of services in specific type of circumstances, you may be prosecuted under specific law. So there are repercussions. So this is the main takeaway that goes beyond the definitions. Now, let's return to the definitions, okay? The way that we often start the conversation about this industry is through the sensational. I mean, we talked about Wagner, as if we have billion Wagners there, and they're all committing war crime all the time. And the fact is, we cannot name 5 companies, organizations like that in the world right now. so we have a skewed sample. I mean, that's the nerd speaking, sorry. So when I approached the field, I was looking at the literature, and that was heavily informed by Blackwater, by NSO, by Wagner, and I figured out that there is a gap between those conversations and the industry. And I wanted to figure out what actually is happening there. So we start collecting data on actors that operating in those settings. Variety of services, and we start categorizing them and catalog them, try to figure out what exactly do they do, how do they operate, where do they operate. Created a sample of 1,700 companies from all over the world. And one of the most important takeaways is that looking at companies that provide direct combat services, as if we have Wagner as example, if we can count as a company or not, we won't get into that discussion. You have only a handful of actors. So what I'm saying is that we really need to be aware of those, and we need to see them as a problem and address them and deal with them. But when we talk about the private military security sector, it's something completely different. It creates some sort of confusion, and it moves our focus into things that sample-wise are marginal, are not representative of the phenomena. So, I mean, okay, again, I'm returning to the samples and whatever. So for those of you who are not playing with statistics and data, it would be as if I will assume that the people in the United States, they're all NBA player, okay? And therefore, I will build policies and assumptions just because we have tall guys that can dunk. So, I mean, it's skewed. It's not a representation. So how the industry actually looks like. If we're looking at private military security companies, now I'm echoing some of the excellent insights you guys provided. We are talking about an industry that provides logistics, maintenance, transportation, translation, communication, housing, and security, among many, many other things. Now, the difference here between those companies and companies that provide similar services in rural Texas or in Geneva here is the setting where they operate and the type of training and skills that they bring into the situation. There is a huge difference between driving a truck in Geneva, providing some sort of moving fuel, than doing that in Taliban land, where you move on the road and you can get ambushed, you can get kidnapped, and you're providing that to a front military base. Now, this is where things becoming a bit complicated. And this is where the gap or the differentiation between the security and the military is becoming blurry or fluid. Some of those services, the moment that you provide them inside conflict area, inside security setting, though you may say that it's just self-defense or it seems benign, they can be considered, in fact, as part of the military operation, de facto. What's happening is that if the military is outsourced function that otherwise military personnel would have taken, you are part of that operation. Take, for example, checkpoints. Checkpoints, they seem, some may argue it's defense. But in a setting of a counterinsurgency, counterterrorism, the command deployed sets of checkpoints as an offensive strategy. The fact that the person sitting there is just defending, as they see it, it doesn't really matter. This is a military tactic. You're part of the military operation. If you take, for example, a mission package, that there is a raid on a compound, on a village, you don't have just the soldiers. You have the K9 services, the interpreters, you have communication, intelligence, transportation. Now, all those are regularly provided by the military. Now, if in that sort of mission package, you have a private company, you can call it whatever you want, but the moment that it's part of this operation, they're providing military services. I'm not saying this is good or bad. It just means that they step at that point into a different legal world that they need to take into consideration. So this is something that we want to think about and address. The fluidity of the definition that depends on the instances, that depends on what you do, where you do it, because this is how the law will interpret it, and also apparently how the data that I collect interpreted. That there is an alignment that you can justify it in the data, you can justify it in the law. Now, I want to because we're talking about the future, that's the title here, right? Future of that industry. I would like to underscore some trends that seems to be emerging, and maybe they will ignite further conversation. So, one, we see the cyber. We see more companies that utilize that sort of space and specialize in it and offering more services. Now, the cyber sphere corresponds also with local capacities, meaning you have more available internet, you have more cell phones in a country. Therefore, you open the door for more cyber. It's about the digital footprint that's produced and therefore can be utilized. So, for example, in Afghanistan, it would be really hard to provide cyber services versus here in Geneva. So there is that. There are packages or clusters of services. The moment that a client gets, let's say, an advanced technology that will allow them to detect missiles or whatever, it can be coupled with additional technology, an additional skill, the transportation that will help that system, the protection system that will help that system, and upgrade to that. So there are those clusters. The moment that a client gets specific skills or specific technology, it opens the door to a host of other skills. Other trends correspond with climate. We can expect to see more services associated with aid and relief and development, and with border security. And the last point is that if we are returning to the hot topic, to the mercenaries, this is a question. How would this panel or everyone here will see militias? Because militias, in some cases, might fit those definitions, and they are way more active than Wagner. So that's something to take into consideration. So again, thank you. And
thank you very much. So I give straight the floor to Alex to continue the conversation.
Thank you, Vincent. Basically, being the last one on the panel, I can just repeat what my esteemed colleague said, smile and try to look intelligent in doing that. But please let me try to do what I do for a living, that is provide scenario and some forecasting. And I think we just have in this line of business few years before AI is coming and take the whole sector. At the moment, we are living at an inflection point. What I mean by this? The global security arena is in transition. the United States is moving to its previous role of offshore security balancer, meaning that the US is going to intervene with less boots on the ground, with more over-the-horizon operation, where it fit. From the part of the world that I come in, that is Asia, this means there are more countries have agency, and the name of the game today in security is regional recalibration. What I mean by this? For example, today, I'm sure here in Geneva, still the buzzword is what's happening in Ukraine, and rightfully so. But if you look at the Middle East, if you look at Singapore, and if you look at China, today, the discussion is President Xi Jinping visit and meeting probably with Mohammed bin Salman, de facto crown prince in Saudi Arabia. And what does mean this for security? That there is agency, and the regional power are trying to have more scope and more possibility of maneuver. And what this means for private military and security. I'm not going to the definition, I'm not going to touch the MS or the other kind of thing. It means that in a time, as we are now, as I said before, of high uncertainty, there are a lot of new and old, non-traditional, non-state security actors that range from private military company, that is still a definition that is anchored to Iraq and Afghanistan, and to mercenary, that is a much old definition. Of course, coming from Italy, the land of Machiavelli, the land of the lens for hire, and so on, is something that I've been looking at not only through my career, but since when I was a child, and I was always asking, mercenaries considered an old job, the second oldest profession, and when I was raised, what is the first? Nobody answered me, but that's another thing. Having said that, the trend are here, and looking a little bit at the future, what it means. There's been a lot of discussion about definition, and a lot of misinformation, because misinformation and disinformation in the PMC sector, the gray area and the mercenary, is very convenient, because you cannot point the finger and to find the culprit. As Professor McLeod mentioned correctly, Wagner Group is always called by Western media, not by Russia at the beginning, as a private military company. What is private in Russia and what is public is still open to debate, but especially with a company that is just an umbrella term that have inside militia, paramilitary, special force, professional, that are being deployed, as the Western like to say, the tip of the spear of Russia foreign policy. And of course, there is a lot of discussion what Wagner is doing now in Ukraine. I don't find much efficiency in looking in that direction. The real efficiency of nimble, efficient soldier of fortune is in Africa, in providing manageable chaos. What I mean by manageable chaos is an insecurity that can be covered, and it can foster a kind of funding that can avoid sanction. And the lesson learned by Wagner Group operation in Africa is that there are sanctions, but sanctions don't bite much. And others are learning from that lesson. So looking at this future trend, and again, Sorka mentioned it correctly, if we look at Turkey, that is one of the area of operation that we see the future of private military / security / mercenary, whatever you want to call it, because they can change the head operationally in different areas. It have started operating in Syria, then you have company who do, and on their website, they profess to do pure PMC service, augmented capability, defense capability. This company in their website underline how they can provide training service to do anti-tank ambush or this kind of support. But in other area, when they move, for example, to Libya, they recruit in Syria mercenary that have been deployed there. Or allegedly, and I say allegedly because both Ankara and both the company deny that. But in the West, especially from Israel to the UAE to the US, there are more and more proof that is happening of mercenary from Syria being airlifted to Nagorno-Karabakh, to the 44-day conflict. And sad news about, Gloria was mentioned before, or the bad news, is not that we are looking at new technology percolating into the arena. I'm not talking about generic AI, I'm not talking about advanced algorithm, but I'm talking about drone, private military company, private security, mercenary with drone is not something that is going to happen in the near future. It's already happening. It's a very old story. Now we are looking at Ukraine. Of course, for the one of you coming from the military, if you look at Ukraine right now, you can take von Clausewitz, the entire book, and throw it out of the window. Because when you try to unmask armored, you have a $200 made in China drone that spot your troop, and the artillery just annihilated it with an effectiveness of $200. But who basically started this trend? It was not in the military. We are looking, of course, Afghanistan, Pakistan, the Reaper drone, and so on. That's the Rolls Royce of drone. What I mean, a huge price tag. Not many can buy a Rolls Royce, and even if you can buy, it's not sure they're going to sell it to you. So today, the name of the game in drone, also the drone used by mercenary, is related to other countries. It's China and it's Turkey that are competing for the top level sale in the world. I'm not talking about top quality. I'm talking about top sale. And these are the trends that are going to affect the future of private military company. And if we look at this and we expand from the discussion of Russia, from the discussion of Turkey in some respect using the Russian playbook and being a PMC where it's convenient, a PSC when it's just training for police force, maybe in Qatar, for FIFA, for the World Cup, but then moving in other operational area where you need drone and when you need something that come out in these 2 days, and I find quite interesting, frontline training, something that we were discussing before. And these are the main issue that we are going, and we are experiencing it right now, and we are going to see more and more in the future. With an increasing uncertainty, there will be an increasing scope for this actor to provide this kind of service that are a proxy for a state. And as already mentioned, what we are going to talk about militia. So if we talk to the fore, there's been a lot of talk now about, as I said, Russia and Turkey, but if we put Iran to the fore, then we are not talking about mercenary. We are talking about IRGC international operation. But then again, if someone is paid to do some action that involve violence, and it's called a PMU, a militia, or is doing this kind of piloting a remote drone that operate from a country from Yemen and it moved to the UAE of Saudi Arabia, how we are going to classify that in the norm that has been mentioned before. Mm-hmm. And then again, and then I think my time is almost running out. I don't want to take it more for that. If we are looking at cyber operation, again, is nothing that we are going to see in the future. It's already here. The biggest problem is that intelligence operation, intelligence for hire is nothing new. Corporations that use advanced algorithm and sell that in the market don't consider themselves a private military or private security company. At least they can call themselves risk management company in some way, but most of the time they consider themselves an ICT provider. Mm-hmm. But at the same time, they augment the capacity of an army, they augment the capacity of a non-state actor. So the big question looking at the use of drone, if someone is piloting just a drone, non-military one, but it provides agency to an army to inflict damage on another army, is it part of the combat operation, but he's not uniformed? And this is something that the Islamic State was one of the first to discover, using $100 off-the-shelf drone, not only for what is most in the news, loitering munition, kamikaze drone, and so on, no. Using drone for scouting and using drone for media operation. And that's what is, unfortunately, the future is looking at in the coming years.
Mm-hmm. Mm-hmm. Thank you so much. I think that was extremely interesting. So thanks a lot, Alex, for these points. And of course, now we can discuss how the law applies to these new trends and the tensions that we may face in somehow defining what security means in this chaos, which is perhaps not manageable, of trying to ensure the compliance by these actors. So I'd like to open the floor for questions. Please ask short questions, limit your comments. We know it's a very sensitive issue, so I'd like to avoid that we have long speech or declarations, but let's focus on the issue at stake. And I would like to take a few questions. Perhaps we can take 3 questions. So this gentleman over there, this lady, and this lady. Yes, please. And then we'll take more questions later. I see you. Okay. So 3 first questions. Feel free to introduce yourself.
Yes, Alev Mine of the One Goal Initiative for Governance. To Gloria, you mentioned we need to think about new maybe laws for AI being used by mercenaries. Now the question is, if mercenaries are regulated and AI is regulated, would that not be a redundant introduction of redundant texts, and how to deal with that? And to Sorja, if you would not have a mandator, what would you mandate yourself to do?
All right, thank you for this. So we'll take then this question there. Yes? Over there. So please introduce yourself. Yes.
So Edward Martin from Henderson Risk Limited in the UK. Sorry, I've popped up quite a lot, you guys. My question relates to something that Ori brought up about the use of militia and how militia crossed that boundary from mercenary group to unregulated body. Drawing on the incident in Syria where Lafarge, the French cement manufacturer, were paying money to ISIS and other groups for security. And as far as I'm aware, they've only been indicted under US terrorism law. I could well be wrong on that. But I'm just interested to hear from Gloria and Professor McLeod on how the law relates in incidents like that from a IHL and PMSC perspective.
Thank you for this lady. And then in the second round, we'll take your question and your question there. Yes.
Thanks very much. Una Muirhead from MSS Global. My question is about how to try and focus the attention on the illegitimacy of actors who are basically doing very bad things. And I worry, this is sort of a comment and a question, that the use of a title like PMSC or PMC, which has this kind of, gives a notion of a legally constituted legal entity, which therefore must be doing some good somewhere, as opposed to the word mercenary, which I think everyone understands to be basically a group of people doing bad things for money, or indeed the word militia, which I think is a really helpful one as well, because it gives the same sort of connotations of illegality. So I just wanted to ask the panel members whether, although it's obviously very important to have definitions so that you can hold these individuals accountable for their actions, whether it's helpful to give them titles which make them sound rather legitimate and legal.
Mm-hmm. Okay, so who would like to start? I think the questions for Gloria.
Thank you very much. So I'll start with the first question that was asked. I don't think that there would be any redundancy because for the time being, for instance, if we take autonomous weapons, we don't have a treaty binding upon states where states would, commit not to develop fully autonomous weapons. There are discussions that are ongoing in the international community to have a development of a treaty, but we are not there yet. But let's hope, let's imagine that such a treaty would be adopted. Then it would provide binding obligations for states, but not necessarily for private entities. So this is why, the mechanism would not necessarily be the same. And in terms of capacities, I think that non-state actors, entities, PMSCs have as much capabilities than actually states to develop this kind of new technologies. So this is why I think that we should anticipate a bit and take into account these developments, these technological developments from the perspective of the security sector. Mm-hmm. And if I may abuse the fact that I have the microphone, so you mentioned the notion of illegitimacy, and I wanted to comment on what you said, Ori, saying that if you look at numbers, I mean, the sector is not a sector where you found horrendous violations committed by all companies. And I fully agree, and I think it's an important message that you provided. However, I think that numbers can be here misleading. I mean, if you look at, I don't know, the COVID crisis, for instance, you could say, well, not so many people died from the COVID crisis, but during 2 years, we were paralyzed because of this. If you look at terrorism, I mean, the number of people that die from terrorism is really small, but still states invest billions, trillions to fight terrorism. So I think that because the violations, when they are committed, are touching the human dignity, then we do have to focus on those aspects, even if they are not the majority. So yes, we have to highlight that not all the security sector is, private security sector is involved in IHR and human rights violations, but nevertheless, this should be a priority of the international community.
Mm-hmm. Thank you. Thank you.
So, I'd just like to come on to the cybersecurity question actually as well, because we actually published a thematic report in 2021 on the use of mercenaries, mercenary-related actors, and private military and security companies in the cybersphere. And we didn't draw a distinction in the context of armed conflict. We didn't draw a distinction between kinetic war and cyber war, and that report might be interesting for you. As to what would I do if I could do whatever I wanted, other than be Empress of the world for a day. To be honest, I think I actually don't. The mandate that we have, because it's mercenaries, mercenary-related actors, and private military and security companies, I think it actually gives us a significant leeway in addressing all of the relevant actors. So my predecessors, for example, did a report on foreign fighters. I think that was 2016, and I've not found that we are not able to do the work that we want to do because of the labels that are within our mandate. And it ties in with what Una was asking him. The labels are actually not that helpful, but because we've got this mercenary-related, very fluid term as part of our mandate, we focus on. Are they providing services that fall within the mandate, and are they violating human rights or international humanitarian law? That's sort of what we focus on. So it's what they're doing. It's not what we call them that's important. And I think that's been a message that we've been trying to get through for 15 or more years. We have to remember, mercenary, out of all the labels we've been talking about today, mercenary is the only one that has a legal definition. The others are political choices. If you want to, what you call an organization is a political choice, and has particular connotations if you use a particular label. And we've seen the term mercenary being weaponized and instrumentalized. So, for example, the working group, we did an allegation letter in relation to the three nationals, two British nationals and a Moroccan national who were, Tunisian, forgive me, I think Tunisian national, who were detained and prosecuted and convicted in Donbass. And they were convicted and prosecuted as terrorists and as mercenaries, sentenced to death and sentenced to, I think, 10 years in prison. And they had been part of the Ukrainian armed forces well before the invasion took place. And what we saw was a clear instrumentalization of the term mercenary. And that's a highly politicized decision. When that label is being used, we saw in relation to the assassination of the president of Haiti. There were Colombian nationals who were accused of being mercenaries and being involved in the assassination. So this is another concerning trend that we're seeing people being labelled as mercenaries who don't fit the definition of mercenary. I have something to say about I had something to say about Lafarge, and I've completely forgotten what it was. I'll come back to it.
Yeah, precisely on Lafarge, any comments? But I don't know if you...
I remember.
You remember?
Yeah, I remember what it was. I think the thing with Lafarge is that it points to another trend I don't think we've mentioned, and that's hybridization of security. And we're seeing various forms of hybridization of security in various contexts. So whether it is land or maritime security, where we see public security services either being deployed in a private capacity or working hand in hand with the private sector, or whether it's these other actors being used as private security. I mean, we're hearing reports that migrants who are being detained in migrant camps are being paid by local authorities to act as some sort of private security to beat back other migrants trying to get into a country. So hybridization, I think, is one of the things that is a very alarming trend, and it's one that is not being, in multiple contexts, that's not being properly regulated.
Mm-hmm. Okay, so we can take a few more questions. We started late, so I think we still have time. So we have this lady, then Mr. You've got the mic, and then you can pass it to...
So sorry about that. I guess I'll
have
to go first. Simon from HXEA. I have a question to the experts on the definition of mercenary. Question's practical one, but we'll say it's an alleged use related to the Gulf monarchies' alleged hiring of Western officers embedded in their armed forces, some of them, as well as staffing their infantry corps with allegedly with South American infantry personnel. Do you consider that those people as mercenaries? And if so, how is that different than Western militaries, such as the United States and United Kingdom, allowing non-citizens to serve in their armed forces? Thank you.
All right, thank you. So we have you and then Jamie at the back.
Yes, hello. So I'm Gabrielle from Geneva Center for Security Sector Governance, DCAF. So my question is, you were talking about updating regulatory frameworks, international regulatory frameworks. And I wonder if that's really where we should be focusing our priority, and if it should to tackle new threats such as Wagner or new technologies. Should we not focus more on implementing existing regulatory frameworks on the ground at the local level to strengthen the capacity of oversight actors, of civil society organizations to be able to prevent actors such as Wagner or other PMCs from violating human rights? So that's my question.
Thank you. And perhaps you can pass it on to Jamie.
Thank you very much. I'm saving you the running around. Question for Dr. Arduino, if I may. You touched upon it in your initial comments about the trends and the kind of regional differences. And if we have time, I would like to hear from your perspective how you see those differences in terms of regional trends and the models being adopted. You mentioned Turkey, China, the Belt and Road Initiative. We've mentioned the Wagner Group and also the Western trends as well. Do you see similarities or clear, let's say, contrasts in terms of the models being adopted? And do you see going forward those entities, be they coming from China, Turkey, sort of Europe or elsewhere, choosing different models? Are there different models we can look at in terms of so-called militarization of security and what's being offered? Thank you.
Good. We can relax a little bit and take the 30 minutes, 1 hour, and I will get an answer. I can start with
but you can start, yes, but don't take an hour.
Basically, as I mentioned it before, we are moving from a bipolar to a multipolar world. That's why regional recalibration, in my humble opinion, is quite important. How a country perceives locally a threat when there is no more the United States being the sheriff of the world, and how it's going to play. That's the reason now, for example, if we start looking at the Middle East, why the Abrahamic Accord are working extremely well in some respect because the enemy number one is Iran, and the fear of a nuclear Iran is making coalesce all the countries in the region that just a few days before were not officially talking each other. And I mean Israel, UAE, Kingdom of Saudi Arabia, Jordania, and so on. Professionally speaking, in this area, and then we link to the question made before, we have foreign military working inside another army. That's not mercenary. That's one of the few times that you can say quite straightforward is not the case, because one is a matter of demographic. If you have been in Dubai, I was there just a few weeks ago, the most difficult thing to find in Dubai is a local person. 10% of the population is from local. 90% are migrant workers. Army has this problem too. They need more boots on the ground, so they recruit from all over the region. In the Gulf before, from Oman to Kuwait to Bahrain, mostly they were Baluchi. From Pakistan, they were recruited. But now, increasing need, the war in Yemen and so on, they need more boots on the ground, and the practical choice was Colombia, Venezuela, other part of South America. But they are inside a chain on command and a chain of responsibility. And that's where it makes the difference, with someone is just there for profit and someone that can be held accountable. Because if some of these soldiers make a crime, then there is a proper law where you can point the finger. Moving from the Middle East, then we move to another area that, in my opinion, is a tinderbox for the future to come, but in Europe is a little bit underlooked, is Central Asia. Kazakhstan was considered one of the most secure countries and was on fire just this January. The movement from former president and father of the nation, Nazarbayev, to the new president, Tokayev, and people forgot that in January, just a month before the Russian invasion of Ukraine, Russia, under the CSTO, that is a regional security organization, sent 3,000 men with tanks to secure all the key points in Kazakhstan. And the area is considered unstable, and the threat in the neighboring part, that is China, for a very simple reason. Because you have the Islamic Emirate of Afghanistan that border with most of that country. And in the south part, from Tajikistan to Turkmenistan, you have Iran, again, that is less stable compared to before. So in all this area, you have area where the US is unwilling to be the sheriff, as it was just a decade ago, or just a few years ago, if we look at Afghanistan. And then local country need to pick up the bill and start to be more responsible, but then in vacuum of power and vacuum of security, where countries are unwilling or unable to provide security, that's a huge space of maneuver for legitimate PSC, legitimate PMC, and especially for illegitimate actors. And as you mentioned before, look at China Belt and Road Initiative. Now with COVID, the initiative has been dwindling. But since 2013, when President Xi launched the initiative when he was in Kazakhstan and Nazarbayev University, all over the BRI, the security issue is a big issue. We are not talking about only terrorist attack like the one in Pakistan, in Balochistan. Recently, Chinese educators were killed in Karachi. 9 Chinese engineers were killed with an IA attack in Dasu near Afghanistan. The problem is where there are friction and how to protect. China is not sending the PLA, the People Liberation Army. China has an increasing amount of private security, unarmed private security company that are going to cooperate locally. And this gives opportunity, again, as I said, to different kind of actors. So it's not a bleak picture of the future. It's an uncertain future that we are no more used to that, because we were used to be very relaxed when it was everything black and white during the Cold War. We knew who are the good, who are the bad, and mutual assured destruction was basically giving some sort of less anxiety. Today, the name of the game is uncertainty, and we have to work with that.
Thank you. On the other questions? Yes, please, Gloria.
Thank you. So I'm happy to respond to the question posed by the DCAF representative. And I fully agree with you that the main priority is to focus on implementation. So this is absolutely key. Nevertheless, this argument shall not be used as an excuse to have a paralysis of the evolutions of the regulatory framework. So in certain contexts, it's very difficult to adopt new treaties. So we know that in the community we're living now, obtaining consensus for a treaty is hugely unlikely on issues like that, for sure. But when we have instruments like the International Code of Conduct that are flexible instruments that provide for themselves, at the end of the instrument it says that it shall be updated. There, it's not an impossible aim to achieve. It is quite easy, if I may say, to have an update of the International Code of Conduct. It's not like adopting a new treaty. So this is something feasible. So we should not take implementation as an excuse not to develop the regulatory framework, because it shows also the importance of the question. It attracts attentions around it by courts, by states, and this is why I think it should also be taken as a priority. Thank you.
And accountability is missing from the existing framework.
To continue that line, notice though that, I mean, the moment that we work on the ICoCA code, essentially we work on private security military companies. We don't work on Wagner, de facto. So this is something to take into consideration. They are not members, I'm assuming, right?
Okay, thank you. I think we're coming to a close of this session. Perhaps one last round, asking you maybe two questions. First, what would be your advice in dealing with this uncertainty that we see at the moment? And possibly your advice for ICoCA in terms of dealing with those issues. I don't want to put any of you on the spot. One can start, and so the others have time to reflect. How do we deal with this uncertainty, perhaps, Alex?
I mean, the long answer is from quantum physics. The long answer to your question comes from quantum physics and complex system. There is a huge theory about that from string theory and chaos theory, and I have really no idea what they are talking about. But it sounds very cool to talk about it. Having said that, managing uncertainty is a process, and just for us coming, as I said before, from an era of some kind of militarized, balanced certainty, it's more difficult. But if we look just prior to the First World War and the Second World War, this kind of non-state actor and instability was Monday.
Okay, so this is a difficult question. So I think that we need to recognize that the settings that produce instability, they are no longer dominated by states. So we have so many different actors operating there, and the moment that we will start accounting for them in legal framework, in policies, on the field, in practices, alliances, thinking about way to navigate that multi-actor field. I think that this is the path forward. We cannot just ignore that they are there while they are affecting everything that is happening there.
States have the primary obligation to protect human rights and to prevent human rights abuses happening or violations of IHL. And they also have an obligation to ensure accountability and access to justice and remedy for victims. So states need to step up and make sure that they are not recruiting, training, financing and deploying these kinds of actors. And if they are, and they're committing human rights violations or committing war crimes, then they have to be held to account. The International Criminal Court, which was mentioned earlier, is one potential route for accountability, but only in the most grave situations where international crimes have been committed. But to illustrate how states have made accountability very, very difficult through their actions. In the creation of the International Criminal Court, it only has jurisdiction over individuals. It doesn't have jurisdiction over corporate actors, for example. And so states, made it almost impossible to bring anyone to account. And mercenaries have certainly never been brought to account, or anyone accused of mercenarism have never been brought to account before the ICC or any other international regional tribunal that I'm aware of. I know there was an attempt with Yugoslavia in international or regional mechanisms. No, national level, yes, but not international or regional mechanisms. The ICTY tried to do it in relation to Afghans deployed in the Balkans, but were unable. Most of them were dead by the time they got round to investigating. And so, as I said earlier, huge accountability gap. States have to step up.
Mm-hmm. Thank you. And you already gave us quite a number of advice. I took note of them. But please, for your final word.
Yes, thank you very much. I think this is the kind of events and the kinds of discussion that can help having more clarity. So we have different pieces of the puzzles. I learned a lot by listening to you, so thank you very much for that. And I think that indeed involving different experts, different actors is the way to go to have really a full picture. And ICoCA is probably in a unique position to do that as a multi-stakeholder initiative. You have the opportunity to talk to all the important actors, states, PMCs, the civil society, academics. So take this as a huge advantage in order to bring clarity. Thank you.
Thank you very much, and we also hope to work on these issues with you. So thanks a lot to all of you. Now I think I give the floor to Jamie. Thank you. Thanks. Thank you.
Thank you very much for a fascinating panel. I think we could have had quite a few panels. If I were to take out 2 points, there's a lot of clarity, it would seem, with regard to the legal frameworks, but there's a lot of uncertainty with regard to the context, and there's also flexibility that ICoCA can bring to in terms of how we're structured and the issues that we can address.